Yesterday, we talked about the three biggest defenses that I thought would be applicable to Derek Chauvin in his case. So if you missed that video, definitely go check that out. It was about an hour long. We talked about the three main charges that he was facing and what the best defenses were, in my opinion, if I were representing him as his defense lawyers. And as we were going through it yesterday, there was an interesting, I'm not sure if I covered it or not, but it's very relevant. One of the charges was actually not being charged against him. It had previously been dismissed, and there was some question as to whether or not it should have been dismissed. So early on in the case, let me back this up. Early on in the case, Derek Chauvin and his defense team, they filed a motion to dismiss all of the charges. They said there was no probable cause. They went through and they made their case, and the judge said, well, no, we're going to keep two of the charges, but we are going to dismiss the third-degree murder charge. And this is the charge that we talked about that looks like this. It says specifically third-degree murder. It was perpetrating an imminently dangerous act and evincing a depraved mind with a maximum term of imprisonment up to 25 years. And it said on or about May 25th, when George Floyd was killed, Derek Chauvin caused the death of another, George Floyd, by perpetrating an act imminently dangerous. And so yesterday, we spent some time talking about what imminently dangerous is, and we went through and explained all of the different knee on the neck, knee on the back techniques that many officers throughout the United States and throughout the world use. And there was some question as to whether count two was going to be moving forward against Derek Chauvin. And up until today, the answer was that no, it was not. It was only going to be counts 1 and 3. But now, because of this ruling from the appellate court, literally on Friday, when the trial is starting on Monday, it's starting with voir dire, then this charge can come back. So now he's going to be charged with 3 charges instead of the 2. And so let's go through this. This is the appeal memorandum from the Court of Appeals from the state of Minnesota, Derek Michael Chauvin. This was filed today, March 5th, reversed and remanded, signed off on by Judge Larkin. So if we want to break this down, you can see this is in the state of Minnesota in the Court of Appeals. The way that this had worked is, of course, Derek Chauvin was being charged with felonies for the murder of George Floyd. That was all going at a lower level state court, just a regular county court. And so when the Derek Chauvin and his defense team filed a motion to dismiss the charges, the government appealed that once the judge did dismiss this third-degree murder charge. And it was going through the Court of Appeals, and today the appeals court said, no, judge, you were wrong in dismissing that underlying charge. Let's take a look at what the actual memorandum says. This is about 20 pages long, if I recall. We're not going to go through the whole thing. I just clipped a couple paragraphs out just so we can put some context around what happened here today. But it says here in this pretrial appeal, the state of Minnesota challenges, so this is the government, the prosecutor, is challenging the district court's order, which is the lower level court, that denied the state's motion to reinstate the third-degree murder charge. So here, the government is not happy that they dismissed the third-degree murder charge. They want to bring it back. The state argues, let's go on to the facts section. The appellant state of Minnesota charged the respondent, Derek Michael Chauvin, with second-degree unintentional murder, third-degree murder, and second-degree manslaughter based on the death of George Floyd. So third-degree murder charge was ultimately not here, and we were only left with the second-degree unintentional murder and the second-degree manslaughter. But now this third-degree charge is coming back. Chauvin moved to the court to dismiss the charges for lack of probable cause. The district court denied the motion for the second-degree manslaughter charges, but did grant the motion with respect to the third-degree murder charge. So in doing so, the court said third-degree murder can only be sustained in situations where the defendant's actions were imminently dangerous to other persons. And we spent a lot of time talking about this yesterday. What does imminently dangerous mean? How can it be imminently dangerous if there are a number of other police officers, police departments, police entities, law enforcement agencies around the world that do this on a regular basis? How could it be imminently dangerous? And so what this court is saying is that this third-degree murder charge had to be dismissed because it concluded that they were not imminently dangerous to anyone else other than George Floyd, and this was specifically directed at him. So what they're saying is, and this type of charge, because of the language in the statute, as you can see here, it says imminently dangerous to others with an S, right? And so here, what Derek Chauvin and his defense team is saying was, it wasn't dangerous to anybody else. It was only dangerous to George Floyd. The statute here says others with an S, plural. No, this wasn't anybody else. It was just George Floyd. And the lower level district court agreed. They said, yeah, you're right. It does say others. Here, it wasn't anybody else other than George Floyd. This would be sort of a one-to-one connection. One officer, one defendant, one aggressor, one victim. It wasn't like a similar situation. The analogy that I saw used elsewhere was, well, what would be imminently dangerous to others? Well, a drive-by shooting would be. Okay, if you're driving through a neighborhood and you're just shooting into a building, that is dangerous to others. It's not a one-to-one connection. And so that's what Derek Chauvin and his team, they wanted to distinguish. They said this was not others. It was only George Floyd, and therefore it needed to be dismissed. Now, the court said, no, that doesn't hold any dice. Their rationale was because they issued a precedential opinion, so meaning this has precedent for other cases, which involved a former police officer convicted of third-degree murder in a shooting death that occurred in from a 911 call. This case was decided on February 1st, 2021. Remember that George Floyd was killed on May 25th, 2020. So as Derek Chauvin's case was pending, this other case was settled, State versus Noor. And Noor, who was that officer, challenged his third-degree murder conviction, saying the facts did not meet the statutory definition because his death-causing act was directed at a specific person. So it's sort of the same analogy there. The court affirmed the third-degree murder conviction in a 2-to-1 decision and said that conviction for a third-degree murder may be sustained even if the death-causing act was directed at a single person. So the Court of Appeals is now saying, yeah, you can bring that third-degree murder charge back, no problem. It doesn't only apply to people or to situations that involve others. It can apply also to one specific individual. In this case, that would be George Floyd. So now what does this do? This is kind of a mess because trial is supposed to start on Monday. And if Chauvin now was preparing his defense for the 2 charges and they just added a third charge, well, you could make the argument, or at least his defense team could say, we've been working on this case for a long period of time, and this is a new charge. We've been building our defenses based on what was in front of us at the time, but now the appeals court wants to just tack on an additional charge. We need more time to build up our defense, to do our interviews, and to prepare for that new allegation. But we're in a precarious position because the court also is really, really preparing for this trial. We know the whole city of Minneapolis is on lockdown. They've got barbed wire. There was a previous attempt by some people in charge over there to, connect with influencers there locally to start crafting the narrative surrounding this trial. A lot of preparations are going into this place. So it's not just a simple motion to continue where they just, okay, well, we'll just reset it for next month. We can do it next month. No, they're prepared for it. So this thing has to go forward. What is the judge going to do about this now? This is an order coming from the appeals court back down to the district court, and this is the final part of the decision. It says the court's precedential opinion in Noor became binding authority on the date it was filed. The district court erred by concluding that it was not bound by the principles of law set forth in Noor and by denying the state's motion to reinstate the charge of the third-degree murder on that basis. We reverse the order of the district court and remand the case for reconsideration of the state's motion. On remand, the district court has discretion to consider any additional arguments that Chauvin might raise in opposition to the state's motion, but the district court's decision must be consistent with this opinion. So what does this mean? Well, right now, it looks like that the district court, the lower level court, has to consider this. They have to make a decision on whether they are going to continue the trial or not. So the decision is telling the district court, you have to allow the prosecutor to bring back that third-degree murder charge. But what they are not mandating is how the court processes the case, at least procedurally. They're saying that third-degree murder charge can come back, but what does that mean for Derek? Is he going to be able to be prepared for his trial? Because what happens if not? What happens if this goes forward on all 3 charges? In other words, the lower level district court allows the prosecutors to reinstate the third-degree murder charge. Now, and the trial proceeds as usual. So we start with voir dire on Monday, and maybe trial starts 2 weeks after that. Is that enough time for Derek Chauvin to prepare his defense? I don't know. But if it's not, and the court forces the trial to go on further, and Derek Chauvin loses on that count, well, now he's got some pretty ripe bases for appeals. He can say that his due process was violated. The court basically made it so that he had an ineffective assistance of counsel because they did not give them enough time to prepare, because they forced the trial to happen sooner than it should have. And nobody wants that to happen. That's the last thing anybody wants, is a conclusion to this case and then appeals for the next 2 years because they're trying to sort this stuff out. So now what does the judge do? Do they say, well, you have to be ready to go forward with the trial. We're not moving anything, and potentially open up the possibility of that coming back down. We say coming back or going up and coming back again. You know, sending it up to the appeals court saying Derek Chauvin didn't have any due process, comes back down. We have to do another trial again and go through this whole rigmarole again. Nobody wants to do that. So is the judge going to then continue it? Is the judge going to bump it out another 30 days or another 6 months? Well, then we have to break down all of the preparation. We have to break down all of the facilities, all of the law enforcement. I think they called in 11 different agencies from a number of different places around the country to come on in and secure the environment because of the volatility of the situation. So as it stands right now, I wanted to show you the last screenshot I took from the court docket. And this is what it looks like. So as we can see, a lot of activity in the last 2 days. On March 4th, the state memorandum of law, they submitted an amended motion in limine. Motions in limine are to help sort of set the rules on what the trial will look like. You know, what can cops say? What can a prosecutor say? What kind of lines of questioning can be introduced? And what types of, it's just sort of defining what the rules are. And so they're fighting over that. There's also a motion to compel discovery. They want to schedule a hearing. And then today we have from the government, they filed a motion. They want a proposed order for a protective order. And it looks like the court granted that very recently. So what they were asking for here, the government said that we have all of this federal discovery from the federal investigation that took place. Remember, back when George Floyd died, there was a lot of investigations happening simultaneously. Trump was still in office, and so his DOJ and Bill Barr, if you recall some of the stories that we talked about here, they were investigating this as well. And there was even a plea deal that was being kicked around with Derek Chauvin, but Bill Barr didn't approve it because he wanted the process of justice to play itself out. They didn't want to close this off and get the criticism of giving him a sweetheart deal and then just closing this thing out without having him go through the formalities. And so here we are, and this is now moving forward, but we'll see where it goes. It's going to be an interesting couple of weeks. I think that the judge is probably going to keep the trial on the tracks. This judge has been very aggressive with moving this along quickly. As we've discussed previously on this channel, there are a lot of other cases, a lot of other homicides, a lot of other trials like this that take years before they ever hit the books. And this one, this court and this judge, they are just steamrolling ahead. We'll see how that plays out. Let's jump into some questions over from locals.com. We've got a couple that have been queued up. Want to Know says, what about the legislation for the Police Officers Accountable Act? So I'm not sure. I haven't seen any of that. The Police Officers Accountability Act, if you're talking about the George Floyd Act that I think is in the process in Congress, I haven't taken a deep dive into that yet, but I know that was being passed simultaneously along with H.R. 1, which we are going to talk about today. Another one from Liberty or Death says, a knee on the neck of a handcuffed individual for 8 minutes seems imminently dangerous to me. Others versus other, I think the intent meant plural, as in other than the person committing the act. Okay, that's a good reason. Yeah, that's a good reading of it. I think Liberty or Death, I think you're right? I mean, especially when George Floyd, blacks out and he's no longer responsive. I think at that point in time, and that happens early on, it doesn't take the full 8 minutes for that. It's 8 minutes, 8 minutes and I think 46 seconds. It's even longer than 8 minutes. So, after George Floyd becomes non-responsive and people are shouting at him, I think at that point in time, that's when the criminality kind of kicks into play. And I'm not sure that anything, including the defenses that I talked about yesterday, I'm not sure that anything is going to help alleviate Derek Chauvin from that liability, but we'll see. I understand your point about the others as well. But, others, I think the intent meant plural as an other than the person committing the act. So in other words, if Derek Chauvin was doing something imminently dangerous, that does not include him. It doesn't include his danger to him. So it'd be like, if somebody was, doing something extremely reckless, let's say they're, flinging a firearm up in the air or, blowing up stuff or something, they couldn't include themselves in that equation of being an other person. It means other people external from the actor here. So I think that's a good point. Maybe that's what the court decided, or the appeals court. I just kind of skimmed through that. I just wanted to see what the conclusion was. Pinky 2's in the house. We saw her on Clubhouse last night. If it reads as others, It appears George was an other. Sounds like splitting hairs. What do you think, Rob? And by the way, I recommend to join Rob, Faith, and Ma on Clubhouse. It was very nice to talk to them directly. Oh, thank you, Pinky. It was nice to talk to you. It was nice to hear your voice and kind of get to put a voice to a name. It was good to see you, Pinky. So what do I think? I think this was the correct interpretation from the Court of Appeals. I think that it does apply to others sort of as a, others is a big expansive category. So I think that it would include also another, right? A single other plus multiple others. And I think that the court was giving it that expansive reading versus saying it only means others and it can't include that narrower reading, which would be one other, right? It's like, if I have an apple, I have an apple. If I have multiple apples, I've got multiple apples. If I have multiple apples, I still have an apple, but I also have multiple apples. Right, sort of that. And so I think the court is making it more inclusive, not less inclusive. Good question there, Pinky. Liberty or Death says the court passed the buck down to the district court. I think this close to trial, it would be prejudicial. I think there would be a strong argument for appeal on due process grounds. Yeah, I think it's a good point there, Liberty or Death. And we'll see. I mean, I think that, defense attorneys in this case are just laying down all sorts of potential appealable issues, which is the right thing to do as a defense attorney. You want to make sure the record is clear, and they've got that done. And, we'll see what happens. Now, if Derek Chauvin is convicted on the other 2 counts and also the 3rd count, we'll see what they do with that. They're going to appeal just that 3rd count, probably. And they may actually make some arguments. I would think that they would make some arguments on the due process procedural problems because this late in the game, they might say that it's throwing off their ability to respond appropriately. In other words, this new charge is now complicating the defense of the original 2 charges because now they have to play with sort of a 3rd ball in the air. The rules of the game are changing at the last minute. So his defense attorneys, I think, will definitely object to the trial moving forward vehemently on multiple different grounds just to make sure that the record is clear. When they do lose, they have an option to appeal. Sharon Quidney says, don't you have to have all kinds of discovery, etc. on the new charge? Yeah, you do. You do. And I don't know if there is additional disclosure for that or if that was the subject of this protective order that just came out today. And so, I don't know specifically what obviously I don't practice law in Minnesota. I'm licensed in Arizona and California. And so I don't know, I'm not intimately familiar with the details there on what their discovery rules say, but I think that the argument might be that if voir dire starts on Monday and they have to go for 2 weeks, some of the discovery rules might be pretty short. It might be 10 days, might be 20 days. And so if they can bump out the start of the actual trial, in other words, before opening arguments, then their discovery rules might allow them to meet the rules. They could continue to disclose this material and then tell the defense that they are prepared and that they have to move forward with trial. So we'll see, very last minute ruling. As far as I know today, looks like we're getting started on Monday, regardless of this decision. But the district court probably today, maybe this afternoon, maybe first thing Monday morning, they're going to issue a new ruling, I'm going to guess, detailing what their response is to this appellate memorandum that just came down today. So interesting stuff. We are going to be covering a lot of George Floyd, a lot of Derek Chauvin over the next month. So make sure that you're sticking around. If you are on YouTube, make sure you give us a subscribe. Go find us over on Locals. If you're on Clubhouse listening in, make sure you give us a follow, and we will be sure to bring all the news for the foreseeable future because it's going to be a roller coaster, I think, over the next coming month.